Julie, if we could go ahead and get started, you can tell us a little bit about what you do. I know you are an eviction attorney, but you do other things as an attorney, and you are probably one of our best resources that we have had on evictions, on rentals, on moratoriums, on getting rental assistance. You've been out there in the thick of it. You've gotten to have all kinds of fun in the last 3 years. So I will just turn it over to you and let you tell us a little bit more about what you do and how we get a hold of you. And
Sure. Hi, my name's Julie Anderson. I am the managing member of Anderson and Associates. Our website is www.mo for Missouri, KS for Kansas, LAW for the law.com. Again, mokslaw.com. It's a great resource for real estate investors and landlords to understand. I have a ton of free forms out there, just information, frequently asked questions, things for people in the industry. Years ago, I had some lawyers that were mad at me that I was giving it away for free because they were charging people for those. And I would just rather have you do it right, because at the end of the day, we want clean cases coming to us. We have a number of departments here. We have a bankruptcy department. If your tenants file bankruptcy, or if you're in the middle of a real estate transaction and somebody files bankruptcy, how does that impact you? So we have a transactional department where we're helping people buy and sell single family, multifamily housing complexes. Generally, it's for investment purposes. We have an eviction department where we are evicting people who fail to pay or violate leases. We have a foreclosure department where people fail to pay their mortgage, or if you're doing any type of lending, we're helping lenders make sure their documents are tight. We help with title issues. Essentially, I often say I'm just in the business of keeping real estate investors in business. We're in and out of the municipal courts where most recently, I want to tell every real estate investor, I know you think these kind of petty municipal violations they're no big deal, but after you plead guilty a certain number of times, like, do not come to me with 16 guilty pleas and then ask me to try and keep you out of jail. So we have a little tiny criminal practice just for real estate investors. We're obviously really busy coming back from COVID, figuring out the new dynamics of the court systems, which is kind of why I'm here to talk with you. Happy to answer all sorts of questions. Kim has given me maybe 5 or 6 questions that I will kind of start out with. So the first question was, are there still moratoriums? Are these, COVID-19 moratoriums finished? So technically, there are no longer eviction moratoriums in place in either the state of Kansas or Missouri, unless you still fall under the CARES Act. So if the CARES Act still applies to you, it means that you are taking a Section 8 voucher, you're a part of a Section 8 housing-based project, you have a LIHTC credit or a low-income housing tax credit, or a federally backed multifamily mortgage. And so it's one of those government subsidized programs, and you took a COVID-19 mortgage forbearance. So if you are someone who takes government subsidies and you took a forbearance on your mortgage during COVID-19, then the CARES Act still applies to you. What that means for you in Kansas is that you have to send a 3-day notice to pay or quit for non-payment, along with a 30-day notice. So those 3-day notices still look a little different. I have a sample on the website, mokslaw.com, under the CARES Act. It's under Forms, CARES Act. Or in Missouri, you have to send, for non-payment cases, you'll have to send a 30-day. What I am not saying to you is everybody go out there and send 30-day notices. I'm specifically saying if you took a mortgage forbearance and you're taking a government subsidy, it's worth having a conversation with an attorney as to whether or not the CARES Act still applies to you. Otherwise, everything is back to normal regarding notices. So that's kind of where we are as far as moratoriums, the next question is, are the courts caught up? Yes and no. I guess I could lead with the good news. We are seeing on the Missouri side no delays in Cass or Platte. We are seeing no delays in Kansas, in Johnson, Wyandotte, or Leavenworth. Everything is sort of pre-COVID, back to normal. There's, intermittently somebody might come in and talk about rent relief and they'll get a continuance, but they're relatively short continuances. We're seeing like things just back to normal there in those outlying counties of Cass, Platte, Johnson, Wyandotte, and Leavenworth. We're seeing some slight delays in Clay. We are seeing extensive delays. And I mean, it's just almost mind-boggling, the delays that we're seeing in Jackson County. We're seeing about a 1 month delay in the issuance of summons, meaning we can't get, everybody's frustrated, get our cases filed, get them filed. They're still working on giving us summons for cases that we filed early in March. I think they said by the end of this week, they hope to even be looking at April. That means I can't get any summons to get service on cases that we filed in March yet. We're seeing significant delays in trial settings up to a month to 6 weeks. And we're seeing the maximum delays in lockouts in Jackson County. So if you are leasing properties in Jackson County, the only real true advice I can give to you is do not allow these people to become very far behind, because you are looking at at least a quarter of a year, if not more, for an eviction right now in Jackson County.
Up to a year in Jackson County?
Well, up to a quarter of a year.
Quarter of a year.
3 to 4 months is kind of what we're seeing right now. We hope that picks up. I don't know. At this point in time, it's just mind-boggling to me. I have a new theory that there's a new pandemic. It's called ignorance, apathy, and entitlement. And it is prolific in Jackson County. It's just, they don't have enough clerks to process the cases. The judges are relatively uninterested in moving things quickly. And with all the attorneys that we're going to be talking about, I mean, there's just a lot of entitlement programs where people feel like they are entitled to live for free, as they have been over the last few years.
They're not going to start paying rent all of a sudden?
I don't think so. I think we've gotten into a new rhythm, and it's going to take some true accountability and some hard work ahead. We're struggling every day trying to justify, some of the things that are happening in the city from a landlord's perspective. The good news is that, and the next question was, are rental assistant programs still paying? Absolutely. They're absolutely paying. I have a list that I semi-consistently keep up at mokslaw.com under the tenant resources page, which is just an ongoing list of all the agencies that are offering tenant assistance. And so every time we receive money from an agency, I'll put their contact information up on that tenant resources page. And there are a lot of programs, new programs every day, new charities every day that are paying past due balances as well as advanced rent, depending on the program. I am warning landlords, if you're not having an attorney review this, you really need to look very closely as you take this money from various agencies. What are you waiving? Are you waiving late fees? Are you waiving attorney's fees? Are you agreeing not to evict in the future? So everything is very negotiable. Like, I will not permit any one of my clients to enter into an agreement that says in the future you cannot evict for non-payment. Of course, we would not evict for the period in which they are paying, but I'm not going to allow my clients to agree not to evict if they go into default in the future. But some of my clients are still doing these things outside of the supervision of counsel, which is fine. I think that's a really smart business move. But you need to read it and understand it before you're agreeing to it, because you will be bound by these programs, even though they're negotiable. You might not know that. You can negotiate that you won't agree. You will still take the money, but you won't agree not to evict in the future. You can negotiate these. I mean, we are negotiating them every day. The next question was, how can you get assistance for your tenants? Well, first and foremost, the tenant has to be cooperative. So if your tenant does not want assistance, there's really no way you're going to get their rent paid for them. They have to cooperate. They need to meet the qualifications of the various programs, and they'll have to fill out the application. Most programs will pay the landlord directly. There are a few programs we're seeing in Kansas that they're paying the tenant directly. I've been pretty clear that I'm not a big fan of those programs, in that I think some tenants could be incentivized to take the money and then further not pay the landlord. I think the courts are in agreement with me, but I don't know. I'm not in charge of these various programs. It's just my personal opinion. The truth is, my clients that are having the greatest level of success are kind of stepping into the shoes of becoming social workers, helping their tenants in advance as soon as they're in default, get qualified for these programs. Let's get their past due balances paid. Let's get their future rents paid. And sadly, in some ways, if your tenant is not cooperative, the best way to do it is get it in front of a court, which then is bringing in these free lawyers or bringing in these programs or getting the tenant's attention to start to pay attention to these programs. Yeah.
Filing an eviction on them to get their attention if they won't, is that helping at all?
I mean, absolutely. Right now, depending on the county, there are attorneys sitting in the hallway. There's attorneys sending letters. As soon as we file suits in Jackson County in particular, but anywhere in Kansas City, Missouri, that includes Platte, Cass, Clay, they're sending letters to these tenants saying, like, we can help you for free. We can help you qualify for rent relief. You're going to be evicted. Pay attention to us. We can help you qualify. And then if they show up in court, there's free lawyers standing in the hallway to help them. I don't think that's necessarily advantageous to the landlord all the time, because, you know, if you have habitability issues, if you've got compliance issues, there's a lot. We're seeing more countersuits than ever before. But I mean, we're also seeing a ton of checks. Like, my mail delivery service thought that I now work for the government. Like, we're just receiving bins of government checks every day. You know, they were like, are you the government? I am not the government. But I mean, I think it's a great move forward for landlords that the government is sending so many checks for rent right now. I don't know how long that'll last. You know, I'm not a politician, but I think it's a good state of affairs. If your tenants are not cooperating with you and you're trying to get them rent relief, the longer you wait, the longer someone lives for free, the more likely they feel entitled to live for free because they have been living for free. So I think taking steps towards enforcing your lease, getting these in front of, you know, getting some attention. Let's get some rent relief moving here. If you're not doing it on your own, obviously I have an entire department at my firm that's doing it. I think a lot of law firms do have an attorney or staff within their law firms working specifically to try to get rent relief for these landlords.
I was talking to one of our members at the Tuesday meeting, and he said he's in Kansas City, Missouri, so they don't have one big program. They got a bunch of little ones, but he says he found that the charities, when he had one particular charity, I'd have to go look at it, but he's like, when I work with them, they step in, they call the tenant, they hold the tenant's hand, they explain to them that what's going on, how to get the money, and they walk the renter through it. So it's not just the landlord doing it. Because I think some tenants might be afraid to listen to the landlord or his attorney, that we might be advising them incorrectly. So when the charity steps in and does all that for them, he's having better luck getting the tenants to respond and get all the forms and signatures that they need. And then they help them because a lot of the renters don't have computers, so or access to the internet, so they are able to fill all that out for them too. So
yeah, and then some of the attorneys, once it's in litigation, some of the lawyers have direct access. Not all of them, but a few of them have direct access to emergency funds. So once a tenant is under the he's going to be imminently evicted, I can get a check sometimes, within 24 hours for the full amount of back rent. That's not every lawyer, that's some lawyers. And it depends a lot on the facts of the case and who's entering when. But I can say we're getting checks.
And are you seeing where renters get their check and in 2 or 3 months, they build up another 2 or 3 months of non-rent, and then they're back in eviction and going for the emergency funds, or are they catching up?
No. I mean, we're now through the first round of emergency funding plus 3 months, and we're back to evicting them. I mean, I personally feel like a lot of people, some people are very much struggling. Some people just they haven't paid rent in 20 months, 24 months, 26 months, and they just got free rent for 6 months, 7 months, 8 months, 10 months paid. And perhaps there's still more money to pay more rent for them. So I don't know. I mean, would you pay your rent if you could get it for free? I don't know. I'm going to go ahead and keep paying mine. Yeah.
Do you know if any of these programs have money for mortgages? I was looking on like MHDC and the Kira pages that they do have some kind of programs for mortgages, but I didn't know if you'd heard anything about those.
We are not seeing the foreclosure market pick up as quickly. I think, obviously, I do have a foreclosure practice. I do not have a high volume, prominent foreclosure practice where I'm representing Freddie, Fannie, or any of the federally backed mortgage companies at this time. I have in the past. I don't think that we're seeing them pick up as aggressively as we had initially considered. I think there is some relief money. I think some of those forbearance agreements are just now requiring repayment here in this last quarter. So perhaps they're not delinquent enough. Of course, the bankruptcy attorneys think that as soon as the foreclosures start picking up, then the bankruptcies will start picking up, and the entire legal industry will be abuzz. I don't know. I obviously am not sitting on the board of a national lender at this time. I can say that we're just not seeing quite the number of foreclosures that we had expected in this quarter, but we're in the second quarter now, and we'll kind of see where that goes. I do not believe that there is a general federal mortgage relief program. I think there is some VA benefits that I've heard of, but perhaps it's kind of lender specific.
Well, I know I've been getting recruited. There's a company out there trying to recruit me as an agent for some major banks to be an REO agent. So somebody somewhere thinks foreclosures are going to pick up and they need a whole bunch of REO agents to list the properties. But
yeah, I think that the industry thought that would be the first quarter. It may not be until the second or third quarter.
I was going to catch some of our questions that we've got going on, and I think you've already answered this one, but this question just came in. So if the tenant's already got rent relief, they can apply a second time if they haven't used all 18 or 21 months?
Yes, we are seeing second round applicants who are qualified.
Okay, and then this one is on when you were talking about notices. For Kansas, if I have a tenant on a month-to-month lease and a 30-day notice to vacate option is there for the landlord, does the 30 days apply from the notice date, or does it not take effect until the end of the next full calendar month? So when is the 30 days active for the 30-day notice?
It's one full rent paying term. So generally speaking, most leases are, most rent is due on the 1st. And so if we issued a notice today, April 19th, it would be essentially from April 19th to May 31st, one full rent paying period. Now, if rent was due on the 20th, then you could go from April 20th to May 20th. But you've got to look at the underlying agreement, and it has to be one full term.
You said we're kind of like on the evictions, or we're caught up, but are you seeing that we're having more evictions than we did before COVID or less?
I would say we're still significantly less. I would say they're down significantly, although I would also say there's a number of landlords who thought for whatever reason they could not evict for the last few years. And so they're coming in with just a huge balances. They haven't paid me in 2 years. They haven't paid me in 3 years. Those are probably some of our most litigated cases, like, what were you doing for 3 years? And a
Not
lot of
listening
those,
to you when we had you on, obviously.
they were not listening to me. Also there have been many landlords who just kind of threw their hands up and said, fine, if I'm not going to get any rent, I'm not going to maintain the property, which is kind of going to lead into my next conversation. The world pre-COVID versus post-COVID is very different when it comes to evictions. I took a lot of default judgments. I worked out a lot of things pre-COVID. We were filing a lot of cases. Very few of them were contested. I could talk to somebody in the hall and they acknowledged they didn't pay and it was no big deal. But now, particularly in Kansas City, Missouri, so that's going to include Independence, downtown for Jackson, some clay, some plat, some cast. Tenants now have the right to counsel. City Council has approved $2.5 million to appoint lawyers. Right now, they have just hired their 18th lawyer. I have heard that they're going to go up to 32. I've heard they were going to go up to 32 and then they were going to stay at 18. I don't know what they're going to do, but it feels a little overwhelming for us to have 32 lawyers versus 2 or 3 of us here. And, there are many other landlord attorneys, but that is a lot of pressure coming in on behalf of tenants. The world that used to be where you just kind of show up and collect the rent. And if the tenant wasn't paying, you didn't maintain the property and you just moved on. That is not the world that you're going to live in now. And it kind of is what it is. And I have a lot of hard conversations with landlords every day where I'm like, I'm sorry, but this is where we are. Tenants get free lawyers now. Our tax dollars are going to pay $2.5 million a year after year, to hire 32 lawyers if you own property in Kansas City, Missouri. And they're going to fight. And they're going to use the rules of civil procedure against landlords, and things that we used to get away with or were not relevant to the proceedings now may become relevant. We're having to litigate. We're in multiple hours of trials sometimes over cases that used to take me 10 minutes. We've got to put on the evidence. So bookkeeping is so important. Keeping great records of your clients' complaints and maintenance requests and your responses thereto are just so important. The likelihood of a landlord being sued right now is just exponentially increasing because there's lawyers on the other side, and that's what lawyers do. And you can sit here and look at me and say, like, I hate lawyers. I understand, but it's just, this is the business that you're in. This is the world that you're in. You've got to maintain these properties. You've got to keep good records. If you come back to me or to your chosen attorney and say, I don't keep records, well, what am I going to put in front of the court? You look guilty. It's lawyer on lawyer now. And I don't want to speak poorly of those lawyers, publicly, well recorded. I still think that landlords have good, strong arguments that they should not have to house people for free just because they don't own the property. We have good constitutional arguments. We're making them every day. We're still winning cases, but there's just so many barriers and boundaries ahead for landlords right now. Obviously, the Healthy Homes program is out there, responding to tenant complaints. We now have these 18 lawyers, soon to be 30 or more. We've got fines and more municipal court violations than ever. Things are just kind of hotly contested. And I think it is a result coming off of COVID and the way that our national government has viewed housing and those that provide housing. And, we're going to deal with it one issue at a time. That's all we can do. I really want to communicate back to the industry. Just please keep better records, get some software, require your tenants to give, my best cases are where you require your tenants to submit maintenance requests in writing, not to your text message, please, like to a certain location. And then the absence of those requests will prove that they did not make those requests. But if you just text and do telephone calls from your cell with your tenant and you're just kind of sloppy and relaxed about it, it's just maybe not the industry for you any longer. You can't do it because I can't win the cases any longer if I don't have good evidence and I don't have good business practices. I'm not saying I never win. I do win, but it's very uncomfortable for landlords right now who are not sophisticated, who don't have software, who don't have processes and procedures, who are using leases from 30 years ago that are 2 pages that don't address jury trials and don't address personal injury claims and don't address maintenance. Those are just things that we're litigating all the time. And, we feel bad because we've never had to litigate this so hard before. It's not that we're not equipped to do it. It's just sometimes I'm having to go into court with landlords that just don't have all the tools that I'm talking about all the time. You didn't put in place. Now is a better time than ever. You've got to, if you want to make money in this industry and you want to be sophisticated and you want to win if somebody sues you, we've got to get some better processes and procedures in place. Don't wait until you're in trial.
I have property management software. And so what I do is there's a place in there where, and they can submit requests and stuff on there, which I would prefer they do. And I respond to them and say, please submit this through the portal. But if they were to text or something like that, what I typically do is I always document that in their notes and say, the resident reached out, said the faucet was leaking. I responded and told them I was going to come by tomorrow, but I haven't heard back or whatever like that. Is that as good if I document it and it's timestamped and I say I wrote down everything we talked about, or at least it's some kind of documentation? Is that good?
Yes, that's better. That's absolutely better than some. I have a provision that I really like, and I think it's ideal. It's the tenant is required to immediately report all maintenance problems, including requests for repairs, installation, service, or security-related matters in writing to, the rent-paying address or some website or some portal, some location. Failure to report a problem in writing may result in tenant liability for any damage to the premises. Landlord's written notes on any oral requests do not constitute a written request from the tenant, nor does complying with or responding to any oral request waive the strict requirement for a written notice to this address. That kind of language, of course, is the strongest and best we could go into a trial with, because the arguments that I want right now, we're going to see a whole wave of all sorts of chaos. Of course, we have 18 new hired lawyers, and some of them are are great, and we're working with them every day, and we actually enjoy a few of them. Some of them are crusaders. They're really young. This is their mission, to take property from landlords. They honestly believe that they're going to be able to own these properties. And legal aid has been doing that. I mean, they've been suing landlords to own their properties for failure to maintain them. We're defending landlords in some of those lawsuits as well. That is a statute that exists. I think there's some idealism with some of these younger lawyers that they are truly crusading for free rent, taking your property, mutilating you in court. Is that going to happen? I sure hope not. I mean, we're in trial now. I mean, they really are turning us into trial lawyers more than I would like to be. I'm a real estate lawyer. I want to be a real estate lawyer. I want to help people buy and sell real estate and do deals. But right now, I'm just going to have to litigate for a while. We're going to have to fight case by case by case. What I could just have to beg landlords to do and investors to do is use better documents. Give me something. Give me records to win. Give me evidence that's consistent.
About this time last year, we had a housing provider here in Kansas City that got called out by KC tenants for all these horrible things and on the news and all this stuff. But he was self-managing all of his properties, and you made a comment that he needed to be working with a property management company so that he had all these policies and procedures in place, and then he would be able to prove that he was doing what he said he was doing, or that he could prove the tenants weren't asking for repairs. So,
right. Well, I mean, if you can't do it, first of all, I've seen small landlords that just have a few properties do a beautiful job of this. I've also seen small landlords who they were like, I'm not getting paid, so I'm not going to maintain the premises, and I don't care. It's all good and well until they get sued. Because before, the risk of a landlord getting sued was relatively slim. You got to remember, like 99% of my cases were pro se. Even when they were contested, it was somebody who did not understand the rules of evidence, was not coming with countersuits on the other side. Maybe 1% to 2% of landlords we were defending versus prosecuting, meaning we were the plaintiff. We were saying, tenant, get out. And maybe 2% of the time, the tenants were saying, no, we're going to sue you, landlord. We are going to see waves and waves of lawsuits, counter lawsuits. So not only are we trying to evict somebody, but we're also trying to defend the landlord. And case by case, judge by judge, we're starting to get a feeling for what this looks like. This is a whole new world for the court. It's a whole new world for us. There's no landlord lawyer who could have ever anticipated this. But here we are.
So we're terrifying all these new people that aren't yet in the thick of being a housing provider.
Okay, sorry.
All of this scariness with the attorneys for the tenants, that's in Kansas City, Missouri. So a lot of these issues that we're talking about are almost all in Kansas City, Missouri.
Correct.
Are you seeing that in, say, Johnson County or Blue Springs or Lee Summit, Raytown? Is it quite as horrible as we've been making it sound for Kansas City?
I mean, Raytown, Lee Summit, yes. I mean, we're seeing it in Jackson County. So those attorneys are both in Independence and downtown. They are sending out specific letters in some of the surrounding counties. Legal aid is still actively involved in Kansas. So usually more on the subsidized housing. So the likelihood of us having an entry in Kansas, you're going to see that more in our subsidized housing projects. These are the more eligible or poor. Whereas in Jackson County and in Kansas City, there is no income restriction. So somebody who makes $1 million could get a free lawyer. I mean, that probably would not happen, but in theory, it could happen as a part of the, new $2.5 million legislation. I mean, we're seeing lawyers in all sorts of counties. We're seeing lawyers now making claims in the bankruptcy and federal courts that we've never seen. The other day, a judge in federal court said, what is this? What are they even talking about? Rent relief doesn't mean anything to a federal court judge until now. We're going to start bringing these things all the way up to the federal court through bankruptcy proceedings. We're going to bring them through the federal courts of appeals. We're going to be making law.
I remember at the beginning of COVID, when the eviction moratoriums first came out, I saw she was an advocate for the tenants, writing that after COVID, where we are now, that we're going to be seeing all of the bankruptcy cases for the tenants to wipe out their rent debt through bankruptcy court.
You know what? I think that's a distinct possibility. It's on every landlord to determine your risk. To me, I prefer landlords who say, I have a policy and procedure that I will only permit a tenant to become 1 month delinquent, and then it goes into eviction. If you teach your tenants that you mean business and you treat them all equally, what I do not, I teach 4-hour seminars on fair housing classes. I do not want you to start feeling bad for, the single mother who happens to go to your church versus the Muslim man or the African-American man who came in and screamed at you in the office. You cannot do that. You have got to have strict written criteria as to how you handle evictions, how you handle leasing, have the same lease for everybody, have the same eviction policy for everybody, and make it aggressive. Don't let people not pay you. And when they don't pay you, have a consequence relatively quickly. So what I'm saying is, for my clients that consistently evict early, the tenants don't want to come back there, and they're not that far behind. So it's easy for us to get relief for them for a few months. By the time we get to court, maybe it's 3 months delinquent, 3 months in advance. I'm never going to allow a landlord to agree to not evict in the future. You're getting 6 months rent. Then as soon as they're delinquent again, you've got to get back on your policy and procedure.
Okay.
I sound so naggy. I hear myself. I'm like,
well, you need to have a good lease so that you can control everything, that everything's in the lease. And you need to know how the evictions work. So you did an eviction workshop. I just put the YouTube link in there to get to the recording of that eviction workshop. And I'm getting a lot of questions about the verbiage you just read. And that's, I'm sure, straight out of one of your leases. You're about how they give notice for rent repairs or for repairs. That's part of your leases, but you sell leases, right? How do they get a hold of you, or who do they call to buy your package of leases?
So we have leases for both Kansas and Missouri that are, I call them my lease baby, because it took me like 9 months to write this thing. I had some clients that were writing me like, well, do something simple, like do something that people can understand and read. A lot of the common leases that you'll see, the KCRAR, I'm not saying they're bad leases, they're just really verbose and long. And I think nobody really understands them. So we do have a lease. It's $250. You can order it on my website under the forms. It's like lease order form. Some people are married to their lease, and we'll sit down and I'll incorporate things that I think need to be in it. At the end of the day, there's some real protections in Missouri that if you don't have them in there, I can tell you your lease is worthless. We have the ability in the state of Missouri as of today, and I hope that we continue to have this, right, that you can have tenants waive their right to sue you in the event they injure themselves, or their guests injure themselves, or they die, even in the event that you are negligent in repairing something. Wow, we're one of like 3 states in the whole country that has that ability. Take advantage of that ability. get that language in your lease. You know, everything that I've drafted into my lease, it's for a reason. It's a complete lease package. Of course, there are other leases that are great and I approve of. I would say this, do not download some lease from New York and then, you know, a 2-page lease from New York and try and use it, especially in Kansas. You might be able to get away with it in Missouri, but Kansas is really very strict. So there's a lot of things that you cannot do in Kansas. Kansas judges are very persnickety about their own state and how they enforce documents in their own state.
Okay, and then the other thing we want to do is to screen tenants very well before we put them in our property. And I think Brendan can help us with that because he has David Pickron with Rent Perfect, which is this tenant screening company that Mary recommends. He is actually one of their speakers next month. So definitely, if you want to learn how to screen tenants, you want to go to the Landlords of Johnson County meeting, either live or virtual, next month to learn how to screen. And I know you've met David because David spoke at one of our workshops with you.
Yeah, absolutely.
And if you've been on his website, he recommends you as the best attorney for landlords in Kansas City on his website.
That's great. Well, thank you, David. I think it's really important. You know, I obviously teach seminars on tenant screening. It matters who you put into your investment. It matters how you manage your investment, how you document your investment, and how you get people out of your investment. Not to be super militant, but you know, you're got to be more militant than we ever were before. You just have to have these policies and procedures. We got to follow them. And what we don't want right now as an industry, I mean, if you truly are not taking care of your property, you're not documenting things appropriately, or even if you are doing things right, but you have no evidence.
So everything that we do, we need to be preparing to go to court, even if we never go to court. We need to look at it like we're the cop on Law and Order, that we've got to have a provable case for the DA, Julie Anderson.
I know.
So we got to make sure we document it and make sure that we're doing it correctly.
I mean, on a happy note, we are seeing a pretty significant decrease in housing discrimination complaints right now. I don't know if the energy is just kind of going in a different direction. You know, there was a period of time in which I sat before you and said, I have more housing discrimination complaints than I do evictions. I'm not saying, maybe it's just me. I mean, it's also possible, you know, there's another lawyer that's seeing 20,000 and I don't know, but that doesn't mean that it won't come back. Everything's very cyclical in this industry. And so we have to know, treating everybody the same, regardless of our emotional feelings. You know, I get it. We want to help people. Landlords, you're people, and there's certain tenants that you have empathy for. And I'm all for being empathetic. I just don't think you can do it in business. So even if you own just one rental property or 2 rental properties, it is a business. If you're making any income off of this, or you're in this for investment purposes, you are in the business of real estate investment, and you've got to abide by fair housing laws as well, which means you have to put your personal feelings aside. If you can't do that, I can do it for you. I have very few personal feelings about tenants.
What do you recommend for a housing provider? What should they be doing to avoid eviction?
I think the way you avoid eviction is, from the very beginning, you screen your tenants. You have a higher quality tenant, good communication with that tenant. You talk about evictions before they even move in. Then you kind of take the role of a bit of social work. You know, if they start to get behind, or you're doing good communication, good processes and procedures with them, you're helping them get the rent relief that they need if they're getting behind, or they feel like they need to pay you. And if you have to, I mean, I know nobody wants, I'm not the kind of at least in my eviction capacity, I'm not the kind of lawyer you want to know in my eviction hat, which is what I happen to talk about more with this organization than the transactions. But I mean, you use it when you have to, and start over with somebody better.
So Anu has a question. If we're going to file eviction, when do you do it? If the rent is due on the 1st and they have not paid by the 5th, when can you file eviction?
Also, in the state of Missouri, it just has to be past due. I mean, I don't think this makes any business sense, but you could file an eviction on the 2nd in Missouri. In Kansas, you would have to send a 3-day notice. So it would have to be 3 24-hour consecutive periods. So you couldn't file until the 4th. Now, that doesn't make any sense to file that quickly. I think you should always send out your own past due notice. You should always send out something consistent of all tenants saying, like, I want to work with you. What is going on? Please come in. Please talk with me. You know, your rent is past due. Here are the late fees. They're going to be assessed on this day. But I mean, if rent's due on a certain date, it's late at midnight plus 1 minute after. That doesn't mean it makes good business sense to file that quickly, but you know, we see it just depends on the landlord. We see a lot of people, you know, by the 20th or the 15th, they're saying, we haven't heard from you, so we're sending it over. Sometimes it's 1.5 months. It's all about your business risk. How much are you willing to float somebody? Knowing that it may take 4 months for me to get them out.
I know when we were not good landlords, so you can't learn anything from me. You can learn from my mistakes, but we were always trying to be the nice guy and put together a workout program. But I'm going to say the workout program may work, it may not, but file eviction at the same time so that if it doesn't work, or at least it gives them incentive to work. So
like I said, we're having a good amount of luck from a law firm perspective. Like, once we're in litigation, because there's such an imminent threat of eviction, that we're having quite a bit of luck of them expediting payment. Not saying that you wouldn't get payment without the law firm. I don't know. I can only tell you where we are when we're there. And every program is different. Every lawyer is different. You know, we're dealing with some lawyers who want to work, they're entering on behalf of tenants, they want to work it out, they're getting money to us very quickly. We're working with some lawyers who want to play hardball and they want to negotiate every line of every settlement agreement. We're working with some lawyers who just want to sue landlords. And depending on the facts of the case, I mean, sometimes it's correct. I mean, if you're truly if you've thrown up your hands and you're not maintaining your properties, you might get sued, and it might be hard to defend you. You know, you've got it, whether they're paying you or not. You should have, you know, we went to trial a couple weeks ago. You know, they haven't paid rent in a couple of years, but the landlord also wasn't maintaining the premises. So we've got insect infestations, we've got lack of heat, we've got a leaking roof, we've got water in the basement. You know, if he or she had just called us in the first few months after the tenant wasn't paying, we would have never had to get into all this big mess. But, you know, it is what it is. We still have to defend the landlord. We can't just say, oh yeah, go ahead and take the property. We're not going to give the property to the tenant to live for free indefinitely. And that is not going to be an acceptable result.
Hey, Julie, I thought we might get to this point, but how do you handle damages beyond the security deposit? So example, $1,000 security deposit, but damages are, say, just like $2,000 or $3,000. That doesn't feel significant enough for me to deal with. I usually just write those off. But like, what would be like a minimum that you would say would be worth it to go after a judgment especially when it's going to be tough to collect, in my opinion, when they don't have the money? Or do you have a policy for that, or what would be your recommendation?
I mean, we're always looking at the collectability of any tenant. You know, some tenants have very long-term employment. They're not going to leave. You know, even during COVID, maybe they were laid off from Ford Motor Company, but they've worked there for 23 years in their union. I mean, that's a pretty strong case for us to pursue. One, I can get into Ford and I can serve them there. Two, they're likely not going to, you know, leave their job. So there's no a minimum. I think it's just all about the quality of tenant that you put in the property. I have been in the business, and I think I've been clear with some people, you know, I don't love chasing people between Taco Bell and McDonald's. It's not particularly fun for me to collect 23 cents every other week. Will we do it? Yes. So I think when you're looking at these, my larger, more sophisticated clients are doing semi-regular inspections, whether they're biannual, quarterly inspections of the property to ensure that the properties are not being trashed along the way. And then, I mean, I don't care. We take judgments against people for $500. A $500 lawsuit is no difference to me than a $25,000 lawsuit. They're all the same lawsuit. The question is, what can we collect? So that comes down to the quality of the person that we're trying to collect from.
That's helpful.
When I see a damages case, I can tell you what I want. I want you to wrap up a pretty little package for me, which means I want to see a lease, a a walkthrough. I want you to give the tenant the opportunity to be present at the walkthrough. They never show up, but you should give them the opportunity. They have the right to be present. So I want some sort of letter or correspondence that says we're going to be doing a walkthrough on this date at this time. I want you to send them a security deposit reconciliation letter within 30 days of the walkthrough or the date they moved out. So it's the date they moved out, 30 days, telling them that here's how we anticipate. Sometimes it's difficult to know the actual number. Here's the generalization of numbers that we anticipate. It looks like you're going to owe around $2,000, $5,000, $10,000 after the security deposit is applied. Then another letter that says, here's the actual number, and that matches up with the invoices and the work orders that you have. So some of you have in-house labor. I want you to keep track. How much did you pay that labor, and how many hours did they work on that project? How many light bulbs did you buy? And I want a receipt for that. I want every single line item to match up with a receipt that matches up with a security deposit letter. That's a pretty little package, and I can walk in and win. Now, if you just give me a pile of poop, I mean, it'll come down in some poopy way.
So having a good record keeping system like QuickBooks or Buildium or something that tracks money in, money out for everything is very helpful.
Yeah, absolutely. You know, and I want it to match up. So if you're saying, I'm fighting right now about a painting job, you know, where the landlord said it was $2,000 to paint the unit. Well, I also would love pictures. Like, why do you think we needed to paint the whole unit? When you go through that walkthrough inspection, in an ideal world, you have pictures before they moved in and pictures after they moved out. So I could compare to the court. Look how pretty it was. Look how ugly it is. Here's all these invoices that match up with the security deposit letter, and they match up perfectly. I don't even care if it's internal invoices from your own labor or your own, you know, staff or people that are working for you. I just need it to match up perfectly. So it's just I just call it the pretty little collection package. Here's what it was before. Here's this great lease. Here's the option to walk through. Here's where we walked through and took all these pictures. Here's a security deposit reconciliation letter. And here's the invoices that match. Like, I can win that case. Now I have to go and collect it, So hopefully you screen the tenant and they have great long-term employment and bank accounts and they operate above board. The nice thing is, we're going to be here collecting debts for quite some time. So when I don't win in the beginning, not when I don't win, but like if I don't catch money in the beginning, I'll just revisit it. Oh, let's revisit it in a year. Let's revisit it in 6 months.
Because they might have a job or a better job in 6 months or a year that you can collect money from.
And if the client wants to pay the $5 and something for me to transcribe it, generally tenants obviously don't own real estate, but someday they may. And so I can transcribe these judgments as a lien. So once they own real estate, it's liening their real estate. So we get paid at closing semi-frequently, once a week maybe.
That's good.
It's a long game. The collection game is not going to be an immediate gratification for the mess that maybe you've been left with. But I mean, we just kind of keep plugging away. Let's see where they're working. Let's see where they're banking. Let's see if I can find new employment. I don't remain terribly hopeful at any point in time unless it's truly higher end rentals. If somebody's truly a high income wage earning person, I feel much more hopeful.
Yes. Well, you had mentioned that you used to do a lot more cases that were discrimination cases, and well, maybe they just can't hire anybody to go be test shoppers to create these discrimination cases right now. But those discrimination cases were a lot of those mostly fair housing violations, or were they other discrimination violations?
They were not, we had not seen a lot of shopper cases. We've had some over the years. These were predominantly just tenant complaints.
Okay. But were they fair housing related or
Yes,
just
all fair housing related?
And it's Fair Housing Month right now, if you guys didn't know. And we could sit here for hours and talk about fair housing and get very bored. But National RIA, which we're all members of through Mary's a part of National RIA, we have a free fair housing course. It's like 5 30-minute segments that will walk you through what fair housing is and what you need to do to meet fair housing so you don't violate and end up being in court for discrimination. I think it's there's a few new things that have came on, and right now they're trying to make a source of income a protected class. It's not there yet, but they're working on it. But they're trying to get that here in Kansas City and a few other cities.
I have a question for the emotional support pet. How many emotional support pet can we allow to?
So a tenant is permitted to have as many emotional support animals as they have verification letters. So if a tenant has 4 ESA letters or a letter from a healthcare provider stating that they need 4 animals as an accommodation to their disability, generally what we're seeing is they'll have 4 individual letters that they've purchased online for their 4 animals, and you cannot charge pet rent or a pet deposit because they're not pets, they're accommodations. I try and describe emotional support animals as, if somebody was immobile, you would not tell them they cannot have a walker. If somebody could not see, you would not tell them they cannot have glasses or a set of glasses for short-term vision or a set of glasses for long-term vision. So the law views emotional support animals similarly to a walker or a set of glasses. And as many letters as they have from a healthcare provider, they are permitted animals. The question will become the question before us right now are the free lawyers there to help administer rent relief? And once they cannot get rent relief, will they keep taking on those tenants, or will they start going to more of a offensive position, meaning countersuing landlords as a negotiation tactic? in order to get their rent forgiven, or for landlords to just throw their hands up and say, fine, you can stay. We don't know.
Okay.
We've seen waves of countersuits right now. We're seeing more rent relief, some countersuits.
Okay. Well, I think we've answered most of the questions. Again, your website is mokslaw.com, and they can reach you through your website for questions, or if they want to have a specific issue that they need help with, they can reach out to you through your website.
Sure. Or, I mean, our email is Julie at, Julie at mokslaw.com.
Simple and easy.
Trying to make it as easy as I can every day.
All right. All right, so we got some extras. I will be sharing the YouTube video with your lease workshop. Tell us a little bit about the crime-free housing, because you were on the board at crime-free KC. I can never remember if the KC comes first or last, but crime-free KC, and they do an 8-hour class. I think everybody should go through.
Yeah.
So tell us a little bit about that.
It's a really great program. So it's a lease workshop, it's a fair housing seminar, it's an eviction workshop on the legal side. They also are walking through 4 hours with police officers, understanding how you can add security and safety to your properties, to your doors, to your windows, with lighting, how to prevent crime, how to work with law enforcement officers in preventing crime, handling crime. It's a really great program. They do a controlled marijuana burn, which is wonderful for me, because if we are evicting people for drugs or for marijuana, the last thing I ever want you to do is get on the stand and say, I know it was marijuana because I smoke it myself, or I did it in college. So I really do appreciate that kind of drug training. So if we did have to evict somebody for drugs, you are a certified individual who can identify a drug laboratory, who could identify drugs, who can identify the smell of marijuana without admitting to me on the stand that you used to smoke it in college. That is wonderful for me as an attorney. We also kind of walk through what it would look like if you would ever need to testify in court with me, how that would feel and look, so that it takes away a little bit of the anxiety for people who just don't have a lot of interaction with the court system. So it's a wonderful way in which the police department and civil lawyers like myself, we come together providing information, and it's free information to housing providers to make sure that you're preventing crime, and if you have crime in your property, that you're dealing with it, efficiently and legally.
And that's also another good reason, a way of evicting people, is if you can prove crime and it's in your lease that they can't commit crimes. That you
yes, we prefer to have crime-free housing. Yeah, and the nice thing is it's a good mixture of people who are truly voluntarily attending these seminars, that want to prevent crime, want to understand, want to interface with law enforcement in a positive way, to have better housing and a better relationship with law enforcement. And there's a few landlords that get stuck there by court order.
I went to the class. It was very enjoyable. I learned quite a bit. Are you teaching them, or at least the attorney portion of it, or is Bob still teaching that?
So I'm now teaching the legal section and a little bit of the liaison, sessions, but the police department does the remainder.
Okay. And when they get a sponsor to pay for it, there's free breakfast and free lunch as well. And when I went, it wasn't 8 hours, it was like 7. So
I try to keep it short. I try and do some stretching. Civil law is not the most stimulating topic of all time, but So far, I've only lost a few participants.
All right, well, cool. Well, I think we will go ahead and end it for the night. But I want to thank you for your input and joining us tonight and getting us updated so we know what's going on out there. We will see you the next time. I'm not sure when we'll see you next. Hopefully we'll see you in July at our Harvesters Vendor Night. We usually see you then if you're in town and not on vacation. So,
Great.
all right. Thank you,
I hope
everybody.
I'm on vacation. That sounds fabulous.
Yay!
Okay,
All
great.
right.
Nice
All
to
right.
see you always. Thank you.
All right.